All right, it is the 12th of November, 2025. We are here at the DPSST in the main boardroom, and we are going to call the Corrections Policy Committee to order. Statement here, Corrections Policy Committee Administrative Announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Corrections Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. With that, you want to do introductions?
When I call on you, please state your name and who you represent for the record. We'll begin with you, Chair Hunter.
Oh. Nick Hunter, Marion County Sheriff, representing the Oregon State Sheriff's Association.
Vice Chair Cameron.
Jennifer Cameron, non-management call probation.
Member Aldridge.
Hi, Josh Aldridge, Jackson County Sheriff's Office representing the Oregon State Jail Command Council.
Member Boder.
Margo Bode, non-management corrections.
Member Prosco.
Lori Prosco, Department of Corrections, Ashley.
And then online we have Member Frost.
Sorry, John Frost, Snake River Correctional Institution, ASME non-management.
Thank you. Member Hartford.
Mike Hartford, Oregon Association of Community Corrections Directors.
And then online again, we have Member Langley.
Ted Langley, Lynn County, Oregon Jail Command Council.
Member Mays.
Mike Mays, East Oregon Correctional Institution, ASME, non-management.
Member Steph.
Brian Stephan, Chief of Security for the Oregon Department of Corrections, sitting for the Director.
And now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST.
Cindy Park, DPSSD.
Melissa Langbasho, case coordinator, DPSST.
Kevin McAlpine, DPSSD.
Marie Atwood, DPSST.
Ben Hamilton, DPSSD.
Howell, DPSST.
Chris Anquist, DPSST. Sam Kang, DPSST.
And that's them.
All right, thank you, Juan. Did everyone have a chance to take a look at the minutes? And are there any questions or concerns regarding the minutes as documented? No questions or concerns. Is there a consensus to accept those minutes as documented? Not seeing any objections. We'll accept those minutes. I did not see that there are already administrative closures on this one. So rightfully so, we'll just get the administrative closures. That's a whole box I get to jump out of the way. I'm just saying. All right, professional candidate standards case for review. Looks like we do have a few people that are going to appear in person, so that will take us slightly out of order. Looks like Shane Bond will still be first, and then we'll move on to Bonnie Kessel, and then unless one more person shows up, we'll follow the agenda as written.
Shane Bond.
So I actually found that one this morning. Did have a chance to look at it, but I literally only found it this morning.
Was it only online and not in our books?
Yeah.
It was online, not in books.
Oh, you know.
It was the tough part about looking at the amended agenda. You had to figure out what was amended on the agenda and what it was Shane Bond was added to the agenda.
I'm gonna jump in here. This is Marie Atwood for the record. Could I just get a general idea of how many people on the committee have had a chance to review the materials for this particular case? Maybe by show of hands?
Juan, can you wait a
One
minute?
second.
Do I get
We need
to on the budget?
Show of hands. I see 1, 2. How about online? If you had a chance to read these, looks like a little bit of, okay.
Everybody online.
So considering we have we have a quorum, but we also have a considerable number of people who haven't read the materials for this case. Our options could be to proceed, and those who have reviewed the materials can participate in the discussion. I don't want anyone to feel unprepared or underprepared. Or I suppose we could have kind of a consensus or a vote among the committee to postpone this case to a later date. I'm hesitant to do that because Mr. Bond is here in person. So I guess I'll leave additional discussion on that issue to the committee for now. Does anyone have any particular thoughts or feelings one way or another?
Brian said for the chair, or for the record, to the chair. I also saw it, but it was a last minute. I perused through it, but I was scanning through it this morning as well, just to refresh. I don't feel strong enough to carry the conversation on this.
Ted Langley for the record. I think holding off on allowing the entire committee to participate would be appropriate, in my opinion.
Then it's probably from Rain. Since he drove from Union County, can we allow him to still provide his mitigation now? And then I'm good with holding this till the next time to discuss. But is there a way he can provide his mitigation now?
I actually think that's a pretty good midway solution. This is Marie Atwood again for the record. If all are in favor of that, can you show just by hands or thumbs up? Receive mitigation today. We will get that transcribed and added to the written materials and then revisit the case next time. Okay. I, in that case, will go out and relay this information to Mr. Bond so that he knows what to expect moving forward. And then we'll come back in.
It's 149 pages to review.
On his 149.
Yeah.
Yeah,
Because I
really
haven't.
not complicated at all. That most of those 149 pages, and not to shade the record, but they're police reports.
Well, usually that's what they are for everybody, so. More information or their training records or those kinds of things.
But I would agree, I think it's worthy of, this one's worthy of discussion, so.
Hello, everybody. My name is Shane. I have,
Hang on just a sec for me, Shane.
oh, yes, sir.
First, you can have a seat right there.
Okay.
We're gonna go a little out over.
No worries. You're gonna see the time.
Yeah, but there's no like, there's no actual written dialogue down here. Okay, all right. Good morning, Shane. So you'll have 5 minutes, once the timer starts to provide your mitigation. No questions will be asked, no further participation after that. That 5 minutes will be your time to use as you see fit.
Sure,
Understand?
I do.
Okay.
And Chair, one comment, Cindy needs to present the case first.
Oh. Yeah. Sorry, Shane.
No worries.
Cindy Park for the record. We're here to review Shane Bond. A case was opened by the department after receiving an application for training, or F5, and a criminal history reporting form, or F28, in which Shane Bond disclosed previous criminal dispositions. Because Bond worked as a reserve police officer with the Umatilla County Sheriff's Office from 2016 to 2017, Bond's position requires that his pre-employment criminal dispositions be reviewed before the full committee rather than the applicant review committee. On March 2nd, 2017, Bond was arrested for the offense of driving under the influence of intoxicants in Pendleton, Oregon. He pled guilty on March 28th, 2017, and entered a diversion agreement. And ultimately, Bond failed the diversion and was convicted of the charge on March 28th, 2018. On October 3rd, 2017, Bond was arrested for the offense of DUII in Umatilla County, Oregon, and pled guilty to that charge in January of 2018. Bond was cited on 3 occasions for the offense of criminal driving while suspended, a misdemeanor, April 2017, October 2018, and May 2019, and was convicted in each case. Moral fitness violations. Bond violated criminal law and has 5 misdemeanor criminal dispositions for DUII, 2 counts, and criminal driving while suspended, 3 counts to violate the moral fitness standard of misconduct. Additionally, Bond violated the board's moral fitness standard for misconduct when on 2 occasions he chose to drive a motor vehicle on a public roadway while under the influence of alcohol. His actions placed himself, others, and property at risk of harm. Chair.
So. Commissioner Bond, you will have 5 minutes. Who's got that?
Okay.
You got it.
Okay, Cindy, you ready? Okay.
Thank you for the opportunity to speak in person today. I want to begin by acknowledging that I take full responsibility for my actions. I know that those actions did not align with the standards of someone who is sworn to serve and protect. I do not want to make excuses. I want to take ownership, show the progress I've made, and to express my unwavering commitment to both personal recovery and the values of this profession. Law enforcement is not just a job to me. It's my purpose and my way to give back to my community. I took an oath to uphold the laws and protect others, but along the way, I lost my balance. The stress and trauma of losing someone very close to me affected me in a way I did not fully understand at the time. I let that build up instead of asking for help, and that choice to carry it alone led me down a path that resulted in mistakes that I regret deeply. Since that time, I've made recovery not just a goal, but a way of life. I sought out professional help, counseling, and completed my recovery program. I've surrounded myself with mentors who hold me to the highest standards, and now I have a loving wife and beautiful family who also give me purpose. This experience has humbled me and reminded me what it means to truly serve. Through recovery, I've realized that strength isn't about being invincible. It's about being honest. Honest about when you need help, honest about mistakes, and honest about commitment to change. Those lessons have made me a stronger person, and I think a better officer. I want to make it clear that my commitment to law enforcement has never wavered. I've dedicated years to this career, and that sense of duty remains deeply rooted in who I am. I know that trust is earned, not just given. What I can promise is that I will continue to live the principles of accountability, service, and recovery every day. I want to use my experience, including my mistakes, to help others in this profession who may be struggling. If I can turn my hardship into a lesson that prevents another officer or even somebody I may encounter in the jail from going down that road, then something positive can come from all of this. I recognize that wearing the badge is a privilege that I do not take for granted. My goal is to serve my community with a renewed purpose as someone who understands the weight of that responsibility more deeply than ever before. In closing, I want to thank you for hearing me out today. I stand before you not as the person who made those mistakes, but as someone who confronted them, learned from them, and has grown through them. I believe in redemption, in recovery, and the power of service. If given the opportunity, I intend on proving that the past does not define the person standing before you today. Thank you so much.
Thank you for your testimony. Exciting work.
Chair, for the record, Kathy Calpine. Mr. Bond, can you just inform the group, when are you expected to start the academy?
I believe that would be January. I don't know the exact date.
Okay, but January.
Yes, ma'am.
Okay, just for the, committee's consideration, if we need to put it off, which is fine, it'll be in the next meeting, which then the agency, our department has to decide whether or not we hold off on letting it start in January, or, yeah, and no, this is holding over, and should you, the committee recommend taking action, then we've got to wait for the board, it could be well into the academy, so, and we've experienced where we've had to remove, and that's not a good feeling for either side either. So just, that's just one consideration, when we're deciding whether or not you can, the committee feels like they can move on today or not.
Yeah, kind of for the record, Deputy Director, I want to ask one more question. I'm just not sure if that question, for me to ask that, is appropriate to ask that in front of Mr. Vaughn sitting here right now.
Well, Chair, I think, again, if you want to say for the record, I believe there's a significant amount of committee members who did not get the link or did not have a chance to see it. So I don't think that anybody's able to make a decision today. Is that correct?
Yeah, I would agree with that.
Yeah.
I think my question was going to be over eligibility period, because if you look at the eligibility period, I think that does create an interesting factor in this one. And whether that influences, it's not really our decision anyway, it's the academy's decision. So I guess that doesn't necessarily matter. I think the bottom line is not enough people have had the chance to review and prepare. So it would be my recommendation that we move this to the next meeting.
Concur. And again, Captain Calvin, for the record, I think, Mr. Bond, you were advised kind of in the hallway of the circumstances. However, we want to recognize that you drove a significant way. We wanted to give you the opportunity in this space to be able to give your mitigation. Carrying it over, of course, you could listen in. You don't have to drive all the way here. Your mitigation will be transcribed. Everybody here got a chance to hear it. Of course, we'll always give you space if you want to come back again and give another 5 minutes, but Ms. Park will keep you informed on to the status of that, and we'll also communicate with you on your January start date.
Okay.
Yeah, work for you, Chair?
Yeah, I concur.
So for now, Mr. Mangill.
Thank you all again.
Thank you.
Do they don't want it. Like when, right, we're putting on the top, but it's like, so maybe that's important. We should make. Right, yeah. Yes, and I remember seeing something like that, which I know we get it, but something. It's for balance. Just very easy to remember. Yeah.
Is, isn't it in the lobby and it's not in the lines?
Okay. Thank you, Wilson.
Morning, Ms. Castle.
Good morning.
In a minute here, we'll have the case read, and then once the case is read, you'll have 5 minutes to provide your testimony. Won't involve any questions or follow-up or anything else, but that 5 minutes will be yours to use as you choose. Understand?
Mm-hmm.
Okay. We will have the case introduced by Melissa.
Melissa Langbasher for the record, morning, Chair and Corrections Policy Committee members. The department opened a professional standards case to review Bonnie Kessel's separation from the Umatilla County Community Corrections, which was reported to occur as part of a settlement agreement. Her separation followed an internal investigation with sustained findings that she was untruthful when questioned about the release of information and failed to meet performance standards. Kessel's untruthfulness was related to a disclosure of information to an employee of another agency that an offender was the subject of an active criminal investigation. When Kessel was asked if she disclosed the information, she denied that she talked about the offender's investigation. The department reviewed the information and previously presented the case as an administrative closure to the committee in May of 2025 and has returned the case at the committee's request. The department again did not find sufficient information to make findings in this case. And Chair Ms. Kessel is here to provide a verbal statement to the committee for consideration. You're ready.
Thank you, Melissa. Okay, Ms. Kessel, you will have 5 minutes. There'll be a timer that sits right here that'll show you. It's right, actually. We'll show you from right there. And the floor is yours.
Okay, so my name is Bonnie Kessel. I worked for Umatilla County Community Corrections for 16 and a half years. Part of the latter part of my years, I was a supervisor. I didn't do the best at that position. And as a result, I stepped down almost a year prior to this situation that occurred. With the person that we're speaking of, I did an intake, a mini intake on him, I guess is what you would call it, the day that they had returned from residential treatment. And the treatment providers, our local treatment providers had switched names and actually agencies. So I mean, there was some contention in the office and I wanted to make sure I did a good job. So I did all the information, all the paperwork, and I sent the person down the street to the outpatient. And I can remember speaking with the counselor on the phone, walking down the hallway, and to the best of my knowledge, I said that he was being charged. At the time later, when this occurred, when this came up and I was asked about it, and this was wrong of me, I was in a hurry, we were going to have lunch, everybody was at the restaurant. It was hasty and I didn't recall at all the conversation. To this day, I don't remember the date that I actually seen the gentleman in the office. I don't know what date that was because I didn't ever return to the office to look at any documentation. But I know the day that I was asked about it by my supervisor, I was in a hurry. And yeah, I was just in a hurry. When I left the office that day after I told her I made 2 phone calls. One was to the lady that actually said that I had told her, the counselor, and then one was to my union president because I just called to say, you know, is this something that I need to worry about? But in my haste, without even, I didn't even pay attention when I was being asked, and that's the truth. It was very quick, and as a result, here I sat. There was an investigation. I didn't remember when I got to the restaurant that day. I was pretty upset, and we were having lunch as an office. And one of the office people there was she was a PO tech, and she's the one that said, I was the one that had said to her mother, who was the counselor, that I had talked about it. And so therefore, that's how the information was passed to the counselor. I didn't remember at the time. The conversation I had with the counselor was very brief and walking down the hallway because it's like, is he there? Yeah, I believe he's in the lobby. And I really was trying to do a thorough job because of the contention in the office, because I wanted to make sure that the counselor had gotten the information because the guy had just been released from residential treatment. But that is what happened. And I had two aha moments. When I was doing the investigation, my assistant director asked me what my aha moment was. The first aha moment was when Cassie, the PO tech, told me, "You're the one that said this to my mother." And then the second aha moment I had was when it's like, usually as a probation officer, you don't get asked questions. You don't ask questions of other people unless you know the answer already. So looking back, I realized, Don already had the answer, my supervisor. And those are my two aha moments. I've done some training when it comes to HIPAA. I'm in a position now that I don't have to sign releases of information, but I was always pretty good about having those papers signed. I even did so that day with that gentleman. But I have done some training in regards to confidentiality. I've also done some personal counseling. It was a pretty big impact. I mean, I was with the county for 22 years, just about 16 and a half of that was with parole probation. And it was something that I really enjoyed. It was something, I was really pretty good at it.
Thank you for your testimony.
Okay.
So the committee will now look at the record as presented by the staff report. And is there a consensus to adopt the staff report as written? Chair Hunter, for the record. I'd like to make an amendment.
I believe she desires to leave and not listen to the deliberation.
Sorry,
No, it's okay.
it's okay. We're working through this because it's my first time sitting in this seat. So it's quite possible that I was supposed to tell you that instead of just making
Well, I
you
knew
sit
it,
there.
I just didn't know my cue. Thank you.
Yeah, you certainly can stay if you would like to.
I don't.
Okay, thank you.
Thank you. And this was such a challenge the first time I had to work through this.
Hey,
All right.
you will do just fine.
I got you.
I believe.
So back to my, Nick Hunter for the record. I would like to propose an amendment to the staff report. The staff report has come to us once, come to us again. There is still no finding for dishonesty. I think that there is sufficient information in the record to support dishonesty, whether the deliberations find that to be intentional or unintentional, I believe should be sorted out during the deliberations with this committee. But I do believe that the record itself reflects that dishonesty in some way, shape, or form occurred during this interaction with Ms. Kessel. So I would propose to accept the staff report with the amendment of dishonesty being included.
I'll jump in here. This is Marie Atwood for the record. I just want to make sure the committee members, kind of just for your general awareness, know the administrative rule definition for dishonesty for cases like this can include both intentional dishonesty or reckless disregard for the truth. So
Josh Aldrich for the record. I would second Sheriff Hunter's motion in large part because I do think that it's important to have some open deliberation around the interpretation of the dishonesty in this case.
Nick Hunter for the record. So I guess to be clear then, I was making a motion, yes, that we amend the staff report to include dishonesty, otherwise accepting as written. And sounds like Josh is going to, Lieutenant Aldrich is going to second that.
Yes, I would second that.
All right. We are voting on a motion to amend the staff report to include dishonesty. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford,
Aye.
Committee Member Langley,
Aye.
Committee Member Mace,
Aye.
and Committee Member Stefan.
Aye.
Motion passed.
I wanted to make it, Jennifer, for the record, I don't know if we can just talk about it, but I'm wondering if also, misconduct might be included in this, and I don't know about the definition, specifically, but what bothers me about this case is that there was information that was shared that, could potentially interfere with an active investigation, which I think harms the agency potentially that was doing the investigation, but also the credibility and the working between the agencies. And the misconduct definition is conduct that violates criminal laws or conduct that threatens or harms persons, property, or the efficient operations of any agency or discriminatory conduct. And I don't know if it would fall to that, efficient operations of any agency or not. So I'm throwing that out there just to kind of get a feel for what people think.
So Nick Hunter, for the record, I'm gonna ask more questions. So we made a motion, we made an amendment that was voted upon, and accepted. And now the vice chair is making another recommendation. Can we have a second motion to amend the amendment and include misconduct?
I don't see why not.
Yes.
Jennifer Howell, for the record, I would say yes, and I would say in essence, you've adopted the record for what the basis of your discussion, and you've already kind of advanced into the concept of amending the moral witness violations, and I don't know if you're officially amending those yet, or if you're just adding these things to the record so that they can be discussion for whether or not to affirm, modify, or negate moral witness, which is a later step. So if there's clarity for the process going forward, as to whether you all are naming these as moral fitness violations now, or whether you're just naming them for consideration.
Nick Hunter, for the record, not to speak for Jennifer, but I think that they have to be identified on the front end of this in that staff report if we are going to discuss them further. Otherwise, we're discussing something not identified.
Okay, I understand that perspective, and so it just may feel a little bit repetitive later on when if you all choose to, and it's fine that it's repetitive because it's keeping the record clear.
Nick Hunter, for the record, I will entertain a motion.
Well, Jennifer Cameron, if possible, I'd like to make a motion to amend the staff report to include, a moral fitness violation of misconduct, which includes, conduct that can affect the efficient operations of any agency.
Ed Langley, for the record, I would second that.
So we have a motion and a second.
All right, we are voting on a motion to amend the staff report to include misconduct. Chair Hunter?
I'm sorry. So we're amending the amended staff report just for clarity's purposes.
Yeah.
So the amended staff report has dishonesty added, and this amendment of the amendment is adding misconduct.
Yes.
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Stefan.
Aye.
Motion passed.
Okay, we'll open the case up for discussion. Remember to state your name and identifying any aggravating or mitigating factors.
Jennifer Cameron, for the record, aggravating factors include that, information was relayed to, this wasn't necessarily about HIPAA. This was about an active criminal investigation that was, being active and it's not public information, and that information was disclosed to the person who has no need to know that, which risked the offender finding out and ultimately sabotaging an ongoing criminal investigation and other things, which I think is misconduct and not appropriate.
Except for the record, she, when she gave her testimony, I really didn't feel like anything was mitigated, just confirmed that she was talking without thinking.
Mike, for the record, want to note her tenure in public safety, 16 and a third years, it looks like, if this record is correct. By that time you would, and being a supervisor at one point, you would understand confidentiality as well as what lying does to our profession. So with her tenure, she should have known better. I remember, not to opine about other cases where somebody in FTAP had lied, and we discussed giving that person another opportunity because of their length of service. And so I think this is similar on the other side of that, where somebody has been in the business for longer to know better.
Kind of for the record, aggravating factor. During the initial questioning of Ms. Kessel, she denied this knowledge 3 times. I was not clear from her mitigation that she addressed that. She didn't appear to take any accountability for the clear harm that had got caused in this situation. She seemed more to continue to justify it. And on the initial, where she denied 3 times, her third denial also involved a very claused answer where she said, "That's awful. Who would do that?" That's awful. Who would do that is shows intentionality to her response, not as she has proposed it as hasty or nervous. It's actually intentional in how she's responding to that. I'll stop there. Actually, no, I'm going to go long. Nick Hunter, for the record, aggravating factor. There was another question that caused me concern that was asked of Ms. Kessel, and it involved, had she previously shared any confidential information from law enforcement? Her response was, "Not that I can recall." And I believe these were similar to her other responses of not wanting to take accountability for things that she had said in previous situations, as this was all kind of confronted upon her in a single time.
Barb Bowden, for the record. One of the aggravating factors I had was a conversation when she was having with this Jim Myers, and she was asked about, basically she said that she didn't know if it was, or she got her mom and her confused that day when she was talking to her. I would think that you would know who you were talking to. And it just seems like she keeps falling back to like, I don't know. I just don't know if I was talking to her or her mom, or, and then it seems very confusing to me that she doesn't know who she was speaking with and what the actual correct person. So there's a lot of I don't know, and I take the no accountability thing for me is a hard thing, so.
Ted Langley, for the record. I also found it aggravating that for somebody with as much time in service as she has. It's no secret to anybody in law enforcement that dishonesty of any kind is basically a death sentence to your career. And yet she chose not just once, but multiple times to be dishonest when she was questioned.
And kind of for the record, aggravating factor, she shared confidential information. That needs to be brought into the record as well. That kind of aggravating factor. Multiple times, she was asked for information throughout this entire investigation where she provided very specific details about everything else that happened during that day. The only thing that she seemed to be unable to provide was the information regarding what she had told the provider. Every other detail of the day seems to be well addressed, right down to people at a haircut, leaving that haircut, coming to the office. All of those things were provided except for what exactly she told that provider. Any other aggravating or mitigating factors? Melissa, can you move back to now?
Thank you so very much for going slow so I could get all of that. I didn't hear any mitigating information, and for aggravating, I've noted that the information she relayed related to an active investigation and shared with an offender sabotaged a criminal investigation. The mitigation she provided today did not mitigate her actions. With the length of her employment, she should have known that she needed to keep information confidential. She denied 3 times that her actions, she denied her actions 3 times and did not take accountability, which she did not address in her verbal statement. Her statement regarding who would do that to her supervisor shows the intentionality of her actions. And her statement, not that I recall, was also an indicator of this. Statements that were given in the investigation were related to saying, I don't know, and ask questions when she should have known the information, show that she lacks accountability for her conduct. Her dishonesty was multiple times when she was questioned, which she should have known could have a serious impact on her career. She shared confidential information. And at other points in the interview that she gave with her employer, she gave very detailed recollections, and then specifically only did not recall the information when she was asked about the offender, Sheriff Hunter.
Okay. Is there a consensus of the identified factors as have been discussed and Melissa has shared? Okay, with the consensus there, we will now move on to the moral fitness violation. The 3 options that are in front of us are to affirm, which is accepting as it is, modify, meaning making changes, or negating, remove all. And I'll entertain a motion around the moral fitness violations.
So for the record, I'll move to accept the amended allegation.
Motion to accept the staff report with the amended violations.
Jennifer Cameron, I'll second the motion.
All right, we are voting on a motion to affirm the amended moral fitness violations as presented. Chair Hunter,
Aye.
Vice Chair Cameron.
Aye.
Member Aldrich.
Aye.
Committee Member Bowden.
Aye.
Committee Member Pascal.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
So that moves us on to discussion of any period or length of ineligible. Oh. Okay. So the next question that exists is whether as a committee, we want to take action on this case. I'll entertain a motion.
So for the record, I move that we take action on this case, as we've accepted.
Margaret Bowe, for the record, a second.
All right, we are voting on a motion to take action. Chair Hunter.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bowden.
Aye.
Committee Member Pascal.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
And we'll now move on to discussing, if any, ineligibility period. Because this case involves dishonesty, the ineligibility period options would be 3 years to lifetime. I'll entertain a motion and please state your reasoning for making that motion in the motion.
Brian Steffen, for the record, I'll move lifetime because of lack of accountability and almost feels like intentional clarity while she spoke.
Hartford, for the record, I'd set for the reasons. Member stated.
Motion and a second.
We are voting on a motion for a lifetime ineligibility period. Chair Hunter.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bowden.
Aye.
Committee Member Pascal.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Steffen.
Aye.
Motion passed.
Does it look like Gutierrez is here, so we can go in order, Chair?
Okay, so Judge No Gutierrez, then we will go back to John Deerdorf.
Chair Hunter, Margaret Bowe, for the record, I just like to state that I actually went to the academy with Deerdorf and have been a personal friend of John Deerdorf as well.
Thank you.
We haven't been in contact for about 5 years, but for quite a long time ago, so.
We will start with Melissa again.
Thank you. Melissa Langbotcher, for the record. The department opened a professional standards case to review John Deerdorf's arrest on March 10th, 2025 for assault in the 4th degree constituting domestic violence. The charges stem from an incident in which Deerdorf's adult daughter called 911 after she was punched in the head by Deerdorf. Deerdorf ultimately pled guilty to the charge and was given a deferred sentence. And in reviewing of the information, the department found that Deerdorf, although not convicted, violated criminal law and obtained a criminal disposition for assault in the 4th degree when he entered a plea of guilty to the charge. And then separately, Deerdorf also harmed another person when he hit his daughter. And the department is seeking a disposition in the case from the committee.
Looking for consensus to adopt the record as prepared. Seeing no objections, we'll adopt the record. So at this point, we will move on to a discussion of aggravating or mitigating factors. Please remember to state your name and identifying whether you are speaking of aggravating or mitigating for the record.
Brian Sutton for the record, mitigating was the 19 years as a correctional officer and 6 years of military service, but aggravating being that he was terminated from service in 2021. Aggravating that he didn't report criminal charges to DPSST. Aggravating that according to his daughter in the report, this wasn't the first time. This is just the first time it was to criminal. And aggravating that although he did admit the assault, he minimized it and tried to justify it by calling her a rookie.
Kind of aggravating. I would word that just a little bit differently, that he was victim blaming in his statement to law enforcement when law enforcement arrived. Yes, it was, he took accountability, but his accountability was that he, I believe his word was, cracked her, and then blamed her for causing him to do that, and said that the victim would boo-hoo and use other language to say all the right things to law enforcement.
Jennifer Cameron for the record. I find an aggravating factor. This is obviously a domestic violence situation. What I read in the report is more that he, it seems that there's a behavior that when he doesn't get his way, he uses threats and intimidation to gain control over people, which is typical behavior for domestic violence. So the intimidation that he attempted to use, I guess, to get what he wanted.
Mike Harford for the record, also aggravating that not only did he take accountability for the assault, but he believes that's an appropriate way to deal with problems by saying he's not going to be disrespected like that in his own house. Like violence is the answer for being disrespected, or if somebody gets up in his face, that the common or the law enforcement folks he was talking to believe that that's an appropriate response for this type of behavior, where to be violent and hurt others.
Josh Aldridge for the record, aggravating circumstances. The plea deal included both probationary and a no weapons clause as part of the ultimate disposition of the case.
Any other aggravating or mitigating factors? If you could read those back, please.
For mitigating, I have noted that he has 19 years of service as a corrections officer and 6 years in the military. And then for aggravating, he was discharged in 2021 and did not report his arrest to DPSST. His daughter reported previous incidents, and he minimized his conduct to law enforcement. Also as aggravating, he victim blamed his daughter for causing him to hit her. He used threats and intimidation to get others to do what he wanted, which was typical and as an indicator of domestic violence. He took accountability for his actions, but then justified them by stating that violence was an appropriate action, and the plea deal restricts his access to weapons. Mr. Chair.
Thank you, Melissa. Is there a consensus on the what are aggravating factors? There were mitigating factors, or yes, there was one mitigating factor that was presented. Okay, we'll open the discussion for a moral fitness violation. The options are to affirm, modify, or negate as presented, and I'll ask for a motion. And it should say, please state for the record why you are choosing to or asking to affirm, modify, or negate. I'll make a, for the record, I'll make a motion to affirm from the record as stated based on the factors, the aggravating factors that were listed out in the discussion. Motion and a second.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Use one vote.
I'll still vote.
Okay.
Yeah.
Committee Member Bowden?
Aye.
Committee Member Pasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
Okay, with an accepting of the staff report as presented, we'll move on to potential ineligibility or time periods of ineligibility. This one does not. The next question is, I will take a motion either for the committee to take action or not take action on this, and please state your name and the reasons why.
Brian Steffen, for the record, I move that the committee take action, or we recommend that the committee take action for the aforementioned reasons.
Nick, I'll second that.
We are voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
Right. Now, based on the motion to take action, we can move on to a motion for periods of ineligibility. Since this one involves misconduct, the available ineligibility periods would be 3 to 10 years.
Brian Steffen, for the record, based on the criminal disposition for assault of fourth degree and constituting domestic violence, I recommend 10 years.
Nick Hunter for the record, I'll second.
We are voting on a motion for a 10-year ineligibility period. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bowden,
Aye.
Committee Member Frasco,
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford,
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
and Committee Member Stebbins.
Aye.
Motion passed.
Next case will be Emily Fisk. In this case, it's presented by Melissa.
Thank you. Melissa Lane back for the record. The department opened a professional standards case to review Emily Fisk's resignation from the Department of Corrections. Her resignation followed an internal investigation into her relationship with an adult in custody after 2 letters were posted by a third party to social media that were between Fisk and an adult in custody. Those letters contained sexually explicit content and a request for Fisk to set up a PO box. During DOC's investigation, Fisk was also found to be untruthful. In review of the information provided to DPSST, the department found dishonesty that Fisk authored a misleading memo that implied an adult in custody had only written her 1 letter, and that the AIC gave her the letter while she was on trial service when neither of those things were true. She was also untruthful during the Department of Corrections internal investigation on multiple occasions. She told investigators that she did not receive additional letters than those posted online when she and the AIC exchanged multiple letters. This told investigators that she only wrote 1 letter to the adult in custody and later admitted that she wrote him 4 letters. This denied telling an adult in custody that she was all his, when in fact she wrote that in a letter to the AIC. This stated in the letters from the AIC were written while she was on trial service. However, the letters were written after her trial service had ended. The department also found misuse of authority. Fisk intentionally used her position as a corrections officer to develop an inappropriate relationship with an AIC to develop to obtain a benefit or to harm another. And for misconduct, the department found that Fisk harmed DOC's credibility and an AIC when she wrote sexually explicit letters to an adult in custody. This harmed the efficient operations of the Department of Corrections when her conduct caused the DOC to conduct an investigation to ensure the safety and security of the adults in custody. This threatened the efficient operations of the Department of Corrections by attempting to set up a PO box for an adult in custody who requested that she provide him with contraband by violating the Federal Prison Rape Elimination Act and DOC policy. And also she threatened intelligence. Cut off there. Threatened DOC's compliance with the federal PREA law, which can impact access to federal funds. Mr. Chair.
Thank you, Melissa. All right. Ask for consensus to adopt the record as shared by Melissa. And that will move us on to open up the discussion for mitigating and aggravating factors. Please remember to state your name and identify whether you are presenting an aggravating or a mitigating factor.
For the record, aggravating factors, dishonesty, not just in verbal, but also in written communication with the Department of Corrections. Aggravating having a relationship with the AIC. Keep going. Somebody else take some?
Jennifer Cameron for the record, aggravating factors, and I'll, add a little, here, obviously lying didn't set boundaries. Her actions, certainly jeopardize the safety of other inmates and staff, which is obviously an issue. I found too that in her letter, mitigating letter, I don't believe that she apologized on her own. It felt like it was more coerced because she said she did it because she was asked to do it by her union rep. You know, in this position, and another thing in this profession, it is our job to make sure we don't allow ourselves to be manipulated. And she put herself into a situation where she was potentially manipulated by an offender when she's the person who's supposed to be in charge. So.
Josh Aldridge for the record, I'll add 2 aggravating circumstances. I don't believe I saw an instance where Ms. Fisk admitted to anything that wasn't already proven to her. I'm not sure that she divulged anything truthful during the course of the investigation. So that's one. The second one I'd like to add is that record in the file shows that Ms. Fisk had went through PREA training only about 3 months prior to these incidents. So very recent and relative training that should have helped her to avoid this decision.
Mike Harper for the record, I'll agree. Her dishonesty was so many times, and every time she lied and she was called on the lie, she continued to lie. So she's incapable of telling the truth. And the second aggravating factor is that even though the AIC was participating, he's in custody and he cannot consent to a relationship like this.
Josh Holder for the record, I'll add one more aggravating circumstance. While there's not support to prove that any steps or that any actual contraband was introduced as a part of this incident, it's clear that Ms. Fisk took steps to initiate contact with a third party, which fell right in line with some of the things in the letter about making a plan to supply that contraband. So I believe based on the investigation, the only reason that that was stopped is because it appears the third party did not respond and participate in that plan.
Kind of for the record, just to add on to what Josh just said, the third party thought he was being scammed and chose not to participate in that. The kind of aggravating factor for the record, it appeared she was actually trying to manipulate and mitigate her own lies along the way as she was trying to make this an incident that occurred while she was on trial services, as opposed to once she had completed trial services. So she was kind of caught in her own lies, but trying to mitigate her own lies, which shows some intentionality that she knew that there were potential consequences coming as a result of these lies. Any other aggravating or mitigating factors? So when you're ready, if you want to read back.
Yes, Melissa Lancaster for the record. I didn't hear any mitigating factors identified. For aggravating, Fisk was dishonest verbally and in writing, and she was having a relationship with an adult in custody. She failed to set appropriate boundaries. Her actions jeopardized both the AIC and staff in the Department of Corrections. The letter she wrote for mitigation in her separation indicates that she was told to write a letter instead of taking accountability for her own actions specifically. She allowed herself to be manipulated by an adult in custody instead of, being aware of, those situations. She did not admit to anything that was not already proven in the investigation. She seemed to be incapable of telling the truth. The adult in custody was not able to consent, to their relationship. There was no evidence of contraband, being supplied, but she took actions and steps to contact a third party as part of the plan for, supplying contraband. A third party chose not to participate in the contraband plan, which ultimately stopped, the supply. Manipulating and mitigating her actions, she manipulated and mitigated her actions to say, that it occurred while she was on trial service, which demonstrated that she knew the consequences of, the lies that she had told. Mr. Chair.
Melissa. Okay, I'll entertain a motion at this point about the acceptance of the moral fitness violations as stated to affirm, modify, or negate, and please provide your reason why.
Chair Brian Simmons for the record, but before we do that, I was trying to find it, and so I'm asking for help if somebody else saw this. Did she accept a friend request from him after she had already
That was
been
the last part of it.
on social media?
Yeah, DOC also investigated this friending on Facebook, a justice involved individual who was on community supervision. without
I
disclosing that
believe
relationship.
that should be added as an aggravating factor as well.
Okay, so one additional, Nick, for the record, one additional aggravating factor, unless I don't believe you need to read that back because that was just talked about.
Yeah.
And so with the additional aggravating factor added, it's now on the table for a motion to affirm, modify, or negate the moral fitness violations as identified.
Brian Seven, for the record, I move to affirm the moral fitness violations as identified.
Are you voting for the record? I second.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Hunter.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bowden.
Aye.
Committee Member Pasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Seven.
Aye.
Motion passed.
Thank you. Now to stay in the correct order, I'll entertain a motion whether we want, the committee wants to take action or not on this case. Please remember to state your name for the record and your reasoning for taking or not taking any action.
Jennifer Cameron, for the record, I recommend that we take action for all the aggravating factors, which include violations of dishonesty, misuse of authority, and misconduct.
Brian Seven, for the record, a second.
Right, we are voting on a motion to take action. Chair Hunter.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bowden.
Aye.
Committee Member Pasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Seven.
Aye.
Motion passed.
Thank you. With the motion to take action, we'll move on to the potential periods of ineligibility phase. Because this one does include the finding of dishonesty, that ineligibility phase or period of time could be 3 years to a lifetime. And I will entertain a motion.
Jennifer Cameron, I recommend that we lifetime ineligibility.
Are you voting for the record? I second. For all the listed reasons.
We are voting on a motion for a lifetime ineligibility period. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Aldrich,
Aye.
Committee Member Bowden,
Aye.
Committee Member Fresco,
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford,
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
and Committee Member Stefan.
Aye.
Motion passed.
Okay. And kind of for the record, we will take a 5-minute break and then come back.